Hi, everyone, and welcome to the Financial Poise Patent Application Preparation webinar. My name is Eliar Barazesh. I'm glad to be moderating this webinar today. The panelists and I are very excited to discuss this topic, and we hope that you find this webinar informative and enjoyable. I'm first going to complete a few housekeeping items, and then we will introduce the panelists and get started. So if you look at slide 2, as I mentioned, this webinar is brought to you by Financial Poise. You can read more about them on slide 2. Slide 3, thank you to our co-producer, the National Law Review. You can read more about them on this slide. Slide 4 contains a disclaimer. To all the viewers, you all are not our clients. We're not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. I'd also like to add that the views discussed during this presentation are not necessarily the views of our employers or our clients and are made only in our personal capacities. So now let's meet the panelists, and I'll let each of them introduce themselves. So first we have Brian Landry from the law firm Saul Ewing. Brian, take it away.
Great. Hi, I'm Brian Landry, partner at Saul Ewing, resident in our firm's Boston office. I work in a variety of aspects in the patent space. I cut my teeth as a patent prosecutor with a background in computer science and doing a lot of work in medical devices and inventions touching on life sciences. And these days, I continue to do a good deal of patent prosecution, but do a lot of contested work, both before the Patent Trial and Appeal Board and in the district courts and the federal circuit.
All right. Thank you, Brian. Next, we have Sanjay Prasad of Appleton Luff. Go ahead, Sanjay.
Good morning. Thank you. Sanjay Prasad from Appleton Luff. I'm based in the San Francisco Bay Area. My practice focuses on advisory and transactional services in IP. I work a lot in the tech industry. I have a background in the tech industry. And I work with emerging businesses, advising management teams on their IP strategy, risks, strategies, budgets, processes, et cetera. And I also work on transactions in terms of licensing between companies and governments and universities. Good to be here.
All right. Thank you, Sanjay. And we also have Patrick Riley. He's been unable to join at the beginning of this presentation, but he may join later on. So we'll also look forward to having him give his thoughts. And my name is Eliar Barazesh. I'm a senior associate at the law firm Baker Botts in Austin, Texas. My practice focuses on patent prosecution and counseling, as well as post-grant proceedings and patent litigation. I like working with startups and established companies to grow their patent portfolios, so I'm really interested in hearing the thoughts of all of the panelists today, and I hope you all are too. You can find more about us on the slide. I think some of the later slides also have our full bios, and if anyone has questions, you all can feel free to reach out to us. So turning to slide 6, just to orient, I'm not going to read this slide, but as I mentioned, this webinar is going to focus on patent application preparation. There can be many stakeholders involved in this process, from inventors, obviously, in-house counsel, outside counsel, management of the company, and the perspectives that we share today will hopefully educate everyone on how to efficiently and successfully navigate the preparation process to ensure that a high-quality patent application is filed in a timely manner. With reference to slides 7 and 8, this presentation is episode 1 of a 3-part series. So we're going to focus on the application today. Later episodes will focus on patent prosecution strategies and portfolio management. Those are scheduled for June and July, and we hope you can join us for those as well. So let's get into this, and we'll actually move forward a little bit to slide 11. So we're going to start out with the basics. So obviously, the ultimate goal of preparing and filing a patent application is to obtain a patent. Brian, can you explain to everyone what is a patent?
Yeah, so a patent is basically a right granted by a government to exclude others from practicing an invention for a limited period of time. So to kind of break that apart, people often that get misunderstand or overlook the exclusionary nature of that. And so, as I said before, it's a right to exclude others. It doesn't, a patent by itself doesn't necessarily give you a right to practice your own invention. And it's quite possible and very, very common that somebody's invention may be a refinement that's dominated by a prior patent. So it's very important, separate and apart from your own activities in filing and prosecuting patent applications, to consider whether you and your company have what's called freedom to operate relative to other patents. Another distinction to keep in mind, especially relative to copyright, which is another form of IP, is that patents differ in that they protect ideas rather than mere expressions. So in the software context, for example, copyright would protect the particular code that somebody uses and whether somebody copies or makes a derivative work from that, but it wouldn't protect the broader idea of what may also be a copyrightable work.
And moving to slide 12, there are a few different types of patents that one may obtain. Can you speak to those different categories as well?
Yeah, sure. So what most people think of if you simply say we're obtaining a patent is a utility patent. And that can protect novel compositions, for example, drugs, pharmaceuticals. It can protect systems, mechanical devices. It can protect software, particularly algorithms that are implemented in computer readable code. And it can protect methods. So it could be for example, a method of refining silver or producing some sort of chemical. It can be a method of training a artificial intelligence device to recognize something. So that's utility patents, and we'll obviously talk about that quite a lot. The other two types of patents, which can be really valuable in the right circumstances, are design patents and design patents and plant patents. I'll hit plant patents first because that's the area I know the absolute least about. This deals with, I believe it's propagation of asexually reproduced plants, and I'm probably butchering some biology there. It's certainly valuable in the industries where it's relevant, and one of the interesting industries that's where this is a increasingly valuable area is cannabis, which I know Financial Poise has some webinars coming up later on this year. But certainly if you're working in that area, you should be aware of it and consult with qualified counsel. Design patents have become much more valuable in the last 15 years or so, and design patents are directed to the ornamental features of a product. So for example, we have an iPhone right here. This product certainly is subject to copyright in its software. It's subject to many utility patents. It's also subject to design patents, both for the overall shape, including the particular curves around the device, as well as the icons. So icons, fonts can also be protected with design patents. And the kind of real important thing to remember with design patents is, even though they differ in a lot of ways from utility patents, they're still subject, at least in the United States and really in most of the world, to the patentability bars that we may touch upon today. So it's important to be mindful of this in the same way that you think of utility patents before you launch a product or otherwise publicly disclose it.
Thanks, Brian. That's a really helpful overview. So moving to slide 13, we're going to get into now some of the considerations that folks should think about when they're choosing to move forward with preparing a patent application. And the first is really choosing your counsel. There's actually a lot of thought that folks should put into this, because choosing the right counsel has a big impact in the quality of the application, the working relationship. So Sanjay, this question for you. I guess, like, how do you suggest that folks choose patent counsel to prepare a patent application? What are some of the thought processes and things to consider when going through that calculus?
Sure, thanks, Eliar. So, choosing counsel, there's a lot of things to consider. Not every counsel or firm is suited for every business or industry. And so, in general, you're going to probably want to think longer term, because as you start to file or change counsel, you're going to want to rely on them, and you're going to actually be investing a fair amount of effort and time into them and getting them to understand your company and your business and your technology. So it's well worth thinking about in advance. And there are a number of factors. There's location. Do you want someone close by to come in and meet in person, or does that not matter? With patents, there's a lot of technical skill sets involved, and so not everyone will have the precise skill set needed, but you can train them, but do you want them to have certain backgrounds so that they understand your industry and your technology and bring some perspective to it, maybe that your own people don't have? And so having some background in that industry or technology can help. You'll need to balance that against actual conflicts or potential conflicts. You don't want them working for a bunch of your competitors, which if someone has a skill set in an area, they may well be in demand in that area. So you'll need to sort that out. And Team, who's going to actually be doing the work. If you have potentially a lot of work, big firms have the ability to be able to put a bunch of people on something and get something done. Small firms don't, but small firms sometimes can be, you can easily identify certain people that you want to work with, and so there's a give and take on there, and depending on your needs, you may want to work with multiple different types of firms. And so just keep in mind that you're going to be putting a fair amount of investment into a firm, and so, or a lawyer. And so you're going to want to be able to work with them over time and make sure they can address needs as they change over time.
Sure. Thank you, Sanjay. There's some great thoughts, and I'd like to actually get a few additional thoughts on one of the things you mentioned is the geographic aspect. I mean, some of the you know, like, we're in a connected world. We're doing this webinar from different places across the country, but do you think that having the attorneys that you're working with have the ability to come in and meet with inventors, every few months to kind of figure out what ideas they have, if they have any innovations that they're working on that they might not have spoken to, in-house counsel or anyone else at the company, in a widespread way. So it's kind of uncovering those type of advancements. Like, do you think that is something that is really helpful, or is it kind of overstated? Do you think that folks can get the same benefit by kind of being more remote and having a long distance relationship with inventors instead? I guess, is the in-person aspect that important, or do you think with the connectivity we have now, it's kind of the importance is lessened?
That's a good question, Eliar. I think my observations have been that the in-person aspect is important and unquantifiable. It's easy to think that, well, people can just get together remotely and it shouldn't be a problem. And so sometimes there's a risk of losing the benefits that you would get from in person. And so if your counsel is in person, is willing to meet in person, that can help. And sometimes over time, as the company builds up the internal capability, that can be reduced because they can do internally what their outside counsel may have started doing externally. But I think the in-person aspect is you shouldn't ignore it, because you may lose things that you can never really identify.
Yeah, I'd second that. And I definitely can think of a couple times in my career where we've done visits to clients, and they offer to take us out on their floor and walk around, and a couple times I've just asked a question, and that's resulted in a patent application being filed where maybe, had you not been there and just been curious, it might have gone overlooked. That being said, certainly, for my practice, and I think for a lot of patent attorneys, if depending on the circumstances, I'm willing to fly most anywhere if it's helpful to the client.
Those are great insights, guys, and that's really helpful for folks to consider. So we're going to move forward a little bit now. Let's go to slide 16. And this is now thinking about some of the business considerations involved when you're putting together a patent application, thinking about what you're going to focus on. Brian, talk to us about this process. What are some of the key things to consider here?
Sure. So patents certainly require significant investments to draft, file, maintain, and enforce. It can be challenging to make predictions, but what I try to encourage our clients to do as they're trying to make these judgments is to approach it from a business investment framework. I think that helps our clients make decisions, which can be difficult decisions, a bit more dispassionately. And so some of the ways that you can think about this as, and this may vary depending on the stage of a company, is what do you do or will your investors want or need? Sometimes, especially in the early stage, you're looking to develop your portfolio in large part with an eye towards being able to make a compelling case for a future funding round. So that's certainly a consideration. Other considerations are what is likely to produce or protect return on investment. And that could be because you have a product line that you're launching and you want to protect that from competitors coming in. It could be that you have a patent family that you believe is monetizable either through licensing or sales or potential enforcement against others. One consideration that we often see in these decisions is the so-called sunk cost fallacy. It can be challenging for companies really of almost any size to let a family go after they've potentially put in $20,000 to $30,000 in filing it. And it's a real thing that we all are aware of. It oftentimes is not the best reason to continue throwing money at it, but it's something that we try to be aware of as we're talking to our clients. And then looking forward, one of the things that we try to do to really help our clients is to preserve optionality. And there's a number of ways that we can do that during the prosecution process. So one of the most common ways that we do it is through using the Patent Cooperation Treaty or PCT application. The way I always encourage our clients to think about this, like an option in the financial sense, in that by filing that PCT application around the 1 year or shortly before the 1 year mark from your earliest application, typically a provisional, you then basically give yourself the option to file in most, but not all foreign jurisdictions at 30 months from that, or 2.5 years from that first application. And that's a really large advantage because filings in a number of jurisdictions, such as Japan and Europe, can be very expensive. Both of those can easily be $12,000. And the quote unquote less expensive ones like China or Canada can still easily run you $4,000. So you stack those up, you're talking about real money. So our clients, whether they're startups or even larger companies, will often use that PCT in order to push those costs down the road, hopefully see what the business case is for the product that's patented or that's recited, and then decide whether or not they want to make an investment in those jurisdictions. We do sometimes see clients just forego the PCT and they'll file directly, but that tends to be very large companies that have a real clear idea where their business is, and you can save some money by making those direct filings, but it's a very mature company play in my experience. Another approach that we try to take is to identify our patent strategy in one or two jurisdictions first. So, for example, for US companies, where we go that PCT route, sometimes we'll file a US non-provisional application in parallel with the idea that we get early feedback from the USPTO, or sometimes Europe, which tends to go fast, or the United Kingdom, where sometimes we'll file in parallel. And any of those jurisdictions give us a good idea of what ultimately may be patentable. And then there's other jurisdictions where if we can hold off, like in Brazil or Canada, if we can delay those, that hopefully allows us to avoid a couple steps in that process where potentially we're responding to the same art multiple places at the same time and not really sure if our arguments are going to work. And then in most jurisdictions, this doesn't work everywhere. We do often like to take advantage of what we call serial in the SERIAL, not the breakfast food sense, to chain those applications together so that we can keep an open application for as long as possible. That gives us flexibility and also allows us to push those costs out into the future where maybe there'll be more resources. Maybe we don't care, but at least we're not incurring those costs right now.
Thank you, Brian. Sanjay, wanted to get your thoughts here as well. Are there any additional considerations that you think folks should focus on?
Yeah, Brian mentioned some timing issues, and one of the things that can be helpful is accelerating prosecution in the United States. And that can be a bit more money, but it can actually result in long-term savings in terms of getting that clarity. And you'll get a patent faster, but also you'll get the information as to the prior art and allowability of certain claims and so forth. And you can use that in foreign prosecution. That can help quite a bit also.
And I guess on that note, how fast, in your experiences, have you been able to get, an initial communication from the U.S. Patent and Trademark Office on an application through the expedited routes? I'd love to hear your thoughts on that.
Yeah, the initial communication, I forget. We've been able to go from filing to issued patent in, I think it was like 12 or 13 months, which the initial communication, I think, probably came in at the 3 or 4 months deadline timing, I believe. But that's been in a few cases where we've been able to get a issued patent in roughly a year, maybe give or take a month or two.
Right. Okay. Well, let's keep rolling here. So there are considerations, obviously, that smaller entities versus larger entities should think about, like different things for different companies, obviously. So Sanjay, maybe you can speak to this one a little bit. So for smaller entities, and maybe those that are thinking about licensing strategies as well that are kind of top of mind, what are some of the thoughts and considerations that they should maybe focus on when they're going through this preparation process?
Yeah, so I mean when you're a lot, I mean, it's one of the jobs of the attorney is to focus the inventors on the invention, and because they may well be focused on their product and all the specifics of doing a product and so forth, and the invention may be a bit different than what they've originally thought of specifically for their product. And so kind of understanding the scopes and contours of that can help quite a bit, kind of teasing that out a bit, because they may not be thinking along the same lines. And what the scope of that is and what may be done certainly within their own company and industry, but how is that used a bit more broadly? And kind of working through that process. With smaller entities, you're going to need to go through the budgeting process and what are things going to cost up front and down the road. Also, with respect to foreign filing, as Brian mentioned, that can get fairly expensive. And then what are your going to be in terms of what are the claims going to cover? Who is that going to cover? Is that going to cover only you because there's no one else really doing it? And who else may be doing it in the future? Can you craft the claims a little bit differently to be able to capture different companies and industries? And then kind of working through the process as it goes through the prosecution and modifying and reconsidering kind of what you need to do based on changes that have happened since your filing. There's a few other things to be aware of. Do you want to file, carve up the technology and file a number of separate applications, or do you want to file kind of one big robust patent application? Then there's pros and cons with either one. The larger single filing can give you a whole bunch of different options as you go through the process, whereas separate filings may not. But those will be distinct, and they can be divided up in different ways down the road. And then also there's the provisional application process in the US, which can be very helpful and save money and time, but also it needs to be carefully considered because there's a tendency to be able to run and file just something in the patent office, and then that may well not be sufficient in terms of the disclosure to support the claims you may want. And then when you go back and actually do the regular filing, it may be too late because of intervening disclosures and so forth. But I think I covered a lot of ground there, but I mean, that's kind of a bunch of different considerations you need to take into account.
Sure. No, and that makes a lot of sense. Brian, like another aspect that I think companies consider is the licensing, like potential licensees. Maybe you can speak to that and how that plays into the preparation process as well.
Yeah, so when we're working with clients, really, whether they're large clients or startups, but I think this is especially relevant for startups, it's really helpful for us to get as much information as we can from the client about what their invention is, what their potential goals are. Obviously, we try to bring our own experience to the engagement, hopefully never kind of pushing things in one way or the other just because we've seen it done a particular way before. But having that information from the client of, all right, we think this is one potential market, versus another, and maybe we want to pursue this but license it, that can help kind of potentially figure out how we're going to go about parceling up the portfolio, whether it's potential applications, a single application, even if it's a single application, trying to get claims in up front for what potential licensing opportunities may be. Another way that we've done this is, for example, in the biologic space, thinking through, well, what are the different steps going to look like along the process of making a product? And maybe some of those are better protected as trade secrets. Maybe some of them have a unique intermediary that hasn't been made before, and that's a really good place to focus patent protection on. There's a lot of different ways to do this, but the more information you can give to your patent attorney within reason, and the more time you can invest in the process in terms of giving the attorney time to work on this and really devoting energies and information to the process, the better outcome that you'll get. To pick up a little bit on what Sanjay said at the end, clients, if they haven't had the experience with the patent process, often really do misunderstand provisional applications. And we file provisional applications first for almost all of our filings. And that's, that includes startups, but it also includes very large, sophisticated universities and companies. And the reason we do that, from my perspective, is there's a little bit of a cost savings. The biggest reason, though, is that if we file an application this month for a client, and in July, the client calls me up and says, oh, hey, I thought of something this morning on the way into work. Oftentimes, we can just file a second provisional application. Maybe we add a couple paragraphs and a figure, and it's a very efficient process to do that second provisional. Whereas if we filed a non-provisional, there's a lot of complexity that goes into what that next filing looks like, which we try to avoid and almost always can. But really the only purpose of the provisional application is to later on support a priority claim. So in a perfect world, we love it where we file a provisional application on day 0. And when we get to 11 months from that, and we're talking to the client, they look at it, really consider it and say, yep, actually, we love it. There's nothing else we need to add because it was perfect the first time. And then we know we can get right back to day 0 for down the road when we inevitably run into prior art.
Those are great insights. And I guess one kind of follow-up question for both of you on this. In the provisional practice, we're going to get into drafting claims a little bit later, but when you're filing provisional applications, do you all prefer to include claims and kind of have a fully drafted claim set with that provisional? So you're kind of defining, the scope of the invention, like with that provisional filing, or are there any benefits to kind of just having your fully drafted disclosure without necessarily having the claims drafted, so you can take a little bit more time maybe to have the client think through how those want to be crafted at the conversion stage down the road? Love to hear both of your thoughts on that.
Yeah, Sanjay, do you want to go first?
Sure. I think it varies. I always like to have a claim. I mean, that's always a goal, so, because it helps to identify what type of details you need. And so having a claim, or at least thinking through the process and putting that into real world language rather than claim language, that can help. So that's always the goal. We don't always achieve it based on the timing and what type of information the client has at that time.
Yeah, I absolutely agree. And when we think about what it takes to get the benefit of priority, it really is a pretty exacting standard in that we go through element by element, and we need to show that we can find that in the provisional application. And in my experience, especially in the software space, but I think this is true in really most areas of the art, it's really hard to do that if you haven't gone through that exercise of thinking about what your claims may be at the front end. Now, there's plenty of times that we do go back and we draft claims, to try to refine things. But in my experience, just the exercise of going through and writing claims really forces you to do a lot of that work up front, which is helpful. Certainly in the US, it's even more valuable in jurisdictions that are particularly strict on written description, such as Europe or China, where I think it would be almost impossible to try to do that without claims in your provisional.
Okay, and we've been talking a lot about startups and small entities here. I think you've touched on both of you have touched on some of the things on slide 20. So I think we'll actually move ahead to slide 22, where we're now going to think about considerations for larger corporations. So Sanjay, do you have any thoughts here about, what are some of the things large corporations should think about when they're deciding how to proceed with the patent preparation process?
Yeah, good question. I mean, and so, larger companies and smaller companies, the business and the technology may well, or is likely to be closer together. Maybe it's the same people or smaller teams of people. In larger companies, the technical development may be very much separated from the business end. And so the technical folks, they'll be thinking of it technically, but they may not be all that clued into what the company is doing doing on the business end. And so as the lawyer, understanding that can help quite a bit in tying those together and asking the questions and so forth. Bigger companies have bigger budgets, and they have the ability to file things abroad and to file multiple applications and to keep applications pending and so forth. And so, going through and asking the questions as to, doing a triage as to where does this fall, how important this is, and reevaluating that can help. My experience with big companies, in some cases, some applications are relatively routine and other ones are very important, and you want to consider them as a family and holistically and always be reevaluating and seeing what you need to do because it covers something really important. And so, with generally big companies, you get a lot more opportunity, and to be able to evaluate and to customize. And sometimes it's easy to overlook that, but you got to keep that in mind.
Absolutely. Brian, do you have anything you'd like to add on the larger corporation?
Yeah, sure. So one of the advantages that we find that our larger companies can often bring to bear is they really just do have oftentimes have a very good domain knowledge of what else is out there that you oftentimes don't have in the startup space or in a pioneering invention. And as a result, in those pioneering applications, you often end up bumping into a whole lot of prior art. Whereas down the road, hopefully, especially if you've maintained some continuity with patent counsel, you just have a much better idea. I have some clients that I've worked with or I've been blessed to work with my entire career rather. And in drafting claims, I think there's a bit of humility you get in that you recognize, okay, well, I don't want to try to throw my arms around the world, because if I do that, I'm going to drag in prior art from this area. So let's try to be focused, and hopefully we end up with more efficient prosecution, just because we draft our claims tighter as we go forward. So some other considerations that we have with larger corporations, we're increasingly seeing them being more open to monetization, where historically clients or large corporations especially that have substantial assets, may have been reluctant to bring patent infringement suits unless there is a particularly egregious situation. What we're now seeing companies do is look at these portfolios and say, well, we've invested quite a lot of money in there. We believe they're actually being practiced by other companies. And so what clients or companies are also increasingly looking to do, or open to at least, is putting those companies into some sort of special purpose vehicle that may license the patents back to that company for them to practice, but then allow them to be asserted without the potential for a cross-claim coming back to the company that originally invented them.
Oh, thanks, Brian. And that's a really interesting point to consider. I guess another question, and I'll open it up to Sanjay as well. Have you, in that kind of process, what are the thoughts about like blowback from going that route, and potentially your competitors maybe realizing that these assets originated from from like the originating company? How does that go into the calculus of that thought process? Sanjay, maybe you can address that question.
It's a good question. It's a big consideration, because if you're looking to monetize, you're looking for some gain, a financial gain from the monetization. Sometimes, people think of monetization as strategic, and maybe there's a strategic benefit. But, if you want a financial gain from it, you don't want to come out negative in that whole process where you go after, you file a lawsuit and you end up paying out more than you got. And so it's a major consideration. I found that the bigger consideration in many companies, I work in the tech field where patent claims don't, they can cover customer activities. And so you want to make sure companies want to make sure that the blowback doesn't extend to customers because they don't want their customers upset. And so, considering the impact on customers, I found to be a major consideration.
Awesome, great thoughts. So we're going to get into a little bit more of the mechanics here. So we're going to move to slide 23, and now we're going to get into the claim drafting part of the preparation process. Now, the most important part of a patent is the claims. That's defining the scope of the invention, what you're covering, what you can exclude others from doing. The name of the game is the claim, coined by Judge Rich. I wanted to throw that into this presentation. So Sanjay, let's talk about claim drafting. What are some aspects you consider when you're drafting claims and going through that whole exercise during the preparation process?
I think the most challenging part of drafting claims is making sure that your client understands what they are. Claim language is somewhat counterintuitive, and once you go through it with people, they understand it, but sometimes they then end up forgetting again. And so, making sure that they understand kind of how claims work is important. And this concept of boundary claiming, and it doesn't have to have every single detail in it to be better. But going through and understanding that, and once your client understands that, that's a pretty fruitful conversation, because you can then start kind of exploring things, and it informs the drafting also, because sometimes it'll highlight things that may not have been apparent in the early discussions. And so getting your client bought into that and understand that process, I think, is very valuable. Once you get along that process, the United States tends to be fairly rigid when it comes to claim language. And so, exactly what is in the claim matters quite a bit, certainly from a patentability perspective, but also in terms of infringement. Again, I work in the tech industry where you get a lot of movement back between what companies do and don't do. And so something that you draft now may not be infringed later on, or may not be infringed by a single party. You may get the multi-party problem. And so, thinking through that carefully, and the different claim language and the different permutations can help quite a bit.
Those are some great thoughts. And I think one thing you mentioned there about kind of the who infringes aspect, like, are there multiple parties that have to kind of work together to meet the claim? I feel like that's a big consideration when you're trying to prove infringement, because there can be some challenges when it's divided between separate parties. So Brian, on slide 24, that who question, can you speak to that and kind of run us through that consideration?
Sure. So although the vast majority of patents ultimately don't get enforced or potentially even licensed, the ones that ultimately have the most value often have that extract or realized through infringement or licensing. So what we try to do is really draft any patent in a way that's going to avoid those issues that we talked about. And some of those issues are a potential divided infringement situation. So just thinking about it from a computer science perspective, if you have a server that interacts with clients, oftentimes that server is controlled by a company, which may be a competitor to the patent owner. And then the clients could be a smartphone that's being used by many customers. So what we don't want to have is a situation in which the claim is reciting either components or activities of two different entities, especially if those entities have potentially a loose connection. And for legal purposes, even a customer could be considered a loose connection. It's not to say that there can't be infringement in those situations, but it certainly introduces an awful lot of complexity, which will at best increase the costs of enforcement and at worst could be fatal to a claim. So really kind of the way that we want to think about this is, who's going to be on the other side of the V, and ideally for each individual act of infringement, it's a single entity. And you want to think about who you'd want to sue. Generally speaking, you want to be suing your competitors, although it's possible to sue potential customers. That usually doesn't engender a lot of goodwill in the marketplace. So generally speaking, we see people trying to avoid that.
Yeah, and Brian, you actually just hit on something that I wanted to ask and raise. So the customer aspect, Sanjay, you actually mentioned this for one of the previous questions. I guess how do you, when you're preparing claims, like what steps do you take to make sure you're not, inadvertently drafting these claims that an end user or one of your customers would actually be infringing? Are there any, what's the thought process that you go through when you're undertaking that task?
Yeah, and Brian touched upon some of this. In terms of looking at what the invention does and who is likely to do it. Sometimes when you look at the entire system that the invention operates in, ultimately it's the customer that's using that system, and so, but they are then they're using services or goods provided by others, and so you want to be looking at what those suppliers do and try and craft your claims to get at them, so that you can go after them without too much additional trouble. You do have certain doctrines of contributory inducement of infringement, which you can use to go after suppliers and basically entities that would be your competitors. Those are more they require more proof, and which sometimes you can't get, and so crafting your claims to cover them directly in terms of what they're doing helps quite a bit. I should say there's another aspect to this. The case law on this has developed quite a bit, and if you look at a bunch of these cases, they came about because the industry changed, and when the patent application was filed, the entities that directly infringed were actually suppliers, and the industry changed, and then the entity that ended up being the direct infringer was the end customer. And so you do need to consider changes that may happen over time, because patents can last a long time, and the industry can change dramatically while it's pending or while during its term.
Makes a ton of sense. So we're going to move on to slide 25 now and look at the claims from a different perspective. And this is subject matter eligibility. So as a little bit of background here, getting the US Patent and Trademark Office to allow, for example, software-related patent claims can be difficult in certain circumstances due to Section 101. That's 35 USC Section 101. And this is kind of an evolving area of law in view of a decision called Alice versus CLS Bank that issued in 2014. And it really dealt with the question of what type of inventions are patent eligible and which ones are maybe not. And as we all know, AI, machine learning innovations are kind of an exploding area. And so this consideration is more relevant than ever before. So Sanjay, can you kind of speak to the subject matter eligibility question a little bit and talk to us about what folks should consider when drafting claims in view of Section 101?
Sure. So, there's a bit of complexity here, as which you touched upon. Generally, subject matter eligibility, it's guided by Section 101 of the Patent Act, which says that you can cover a process, machine, article of manufacture, or composition of matter. In practice, the law is much more nuanced than that, in that over the years, or decades, or centuries rather, there's been developed a number of exceptions that, even though something may be can be categorized as a method or as a machine or process or article manufacture, if it doesn't meet additional tests, it's not going to be eligible. So this comes up a lot, typically in the computer field, particularly in software. It also comes up in life sciences and biotechnology. Between those two extremes, sometimes inventions can get caught up in it if they're claimed a bit too abstractly. If you're ideal, I don't really deal in life sciences. I deal in the tech and software and AI areas, and it's a real issue. You really need to consider it carefully and draft your specification in a way that meets the requirements. And in general, I can say you need to be specific. You need to tie things to technical improvements. That helps quite a bit. And identifying technical benefits can help quite a bit also. And it's not just a matter of claiming. The law is developed in that courts will look at the underlying specification and what's been described and so forth, and really kind of try and figure out what the invention really is, or what the heart of it is, and things that are kind of beyond the pure claim language.
Great thoughts. Brian, do you have anything to add
just to amplify a couple things that Sanjay said. I think that ability to tell a compelling technical or engineering story, in my experience, is probably your best heuristic for what will get allowed. We could spend an hour discussing and probably critiquing the way the U.S. case law is developed on this, but that ultimately seems to be the guideline. And what I've experienced, we do a lot of work for academic institutions, and I find that even though a lot of those inventions that we receive certainly touch upon math, and potentially it could be argued to encapsulate an abstract idea, where you have an academic manuscript that's behind it. They just tend to be much more robust inventions and have a lot less one-on-one issues relative to something where you've got an idea, but it's just much more of an extractive process trying to really get that story around it that you just have coming out of the academic space. And then one other thing that I found to be really helpful, oftentimes, sometimes in a surprising manner, is speaking to examiners. I've had some cases where the written office actions would just make you think that the invention was dead in the water from a one-on-one perspective. And we've spoken to the examiner and just found them to be not only just much more engaging in person relative to their writing, to the point where you come away with multiple suggestions of what ultimately can get over the line. And at the end of the day, the examiners are working within a system where they have supervisors, and the USPTO has positions, and certainly doesn't want to be embarrassed by patents that seem like they're incredibly broad. So the examiners are working with their supervisors on a daily basis and have a really good idea of what the office will grant claims on, and where they're going to hold the line.
Those are some great thoughts, and I think that's a good plug for the next webinar, where we'll be talking about prosecution strategies. Examiner interviews play a large part of that. So for all the viewers, stay tuned. You got a little taster there. We're going to move on to slide 27 now, and kind of talk about another aspect of claiming. This is functional claiming. Sanjay, can you give us a brief rundown on functional claiming, means plus function claim elements, and like what those are, and how those can cover inventions in patent applications?
Yeah, and this is something that's become more and more common and important as as technology is changed. Basically, functional claiming is describing something in claims on based on the function being performed rather than the underlying structure. So, a simple example would be a screw is not a elongated metallic object having knurling or something. I don't know the exact language, but a functional claiming for that would be a means for fastening, right? So that raises a bunch of issues in terms of patents. You see the functional claiming issue quite a bit in technology and in circuits and software and so forth, where the important part of what it does is the function that it performs, not necessarily the structure. And you think about it for a second, well, what's the structure for software? Well, the courts have said the structure for software is the algorithm performed and the underlying hardware that performs it. And so, in terms of claiming, if you have a means for processing a data processing object, blah, 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 well, you need to describe how that actually operates in terms of flowcharts and block diagrams and so forth. So that's what functional claiming is. It raises a bunch of issues around description and specifically the specific wording of the claiming. I won't go into it in too much detail, but you need to consider it carefully when drafting. I know in software folks, they tend to not think of the details when it comes to patents, and you need to kind of force them to focus on the details of how something is being done. Sometimes not limited to software people, but sometimes people think they're going to get hemmed in. They don't want to provide too much detail, and that's kind of you need to have them understand that what type of detail is needed, and also that you can't go back and put it in later on if you don't include it up front. So a bunch of things to consider in terms of just drafting and in terms of coverage, but it does impose another set of considerations that you wouldn't necessarily have with other types of inventions.
Yeah, and that's a great overview, and really we've covered all the different considerations for patent claims throughout this conversation. We're going to change gears just briefly for the last few minutes of the presentation here to touch on the specification. So now this is the written description of the patent application that's providing support for the patent claims. So Brian, just briefly, what are a few things that folks should consider when they're drafting a spec?
Yeah, so sometimes we have clients that will draft their own materials and provide them to us, which is really, really helpful. One thing that I always tell our clients is don't try to write like a patent attorney. In my experience, what happens is they tend to find some patent from the 70s, and it's always debatable whether it's the 1970s or 1870s. And it ends up being kind of stilted language that I don't think reflects modern practice. Really, what the most important thing is to try to, when I'm training associates on how to write an application, I imagine them taking an invention and then looking at it from kind of every angle and trying to think expansively about those elements. What materials could it be? What shape could it be? How could you make this? How do these things interact? And the more expansively you can think about that, the more options you give yourself and your client down the road. A couple of things. We try to avoid what we call colloquially patent profanity, saying it must or it's essential. Really kind of anything that's going to lock you in is something that you absolutely want to avoid. And then we mentioned briefly that Europe and China especially have particularly rigid standards. Europe has a couple things, a couple doctrines that make our lives challenging, including what's called intermediate generalization. And so what you can often find yourself in is if you have to broaden your claims, as you often do, you can find yourselves with challenges in Europe, especially if you have to go and look at the drawings. So, the more time you can spend on the front end thinking about where you may end up, the easier your life will be.
Great thoughts. And Sanjay, to kind of round us out here, I'm going to actually condense the cost control and the invention disclosure topics together because they're kind of related. So I guess, when we're seeing an invention disclosure come in? So an engineer kind of has their ideas for an invention. They've maybe submitted it to in-house counsel or to whoever's running kind of the patent program. And you're kind of budgeting out and thinking, you know, how much is this going to cost? What are some of the thoughts about cost control and analyzing how much applications, how much budget should actually be allocated to a particular patent application?
Yeah, I mean the best is you can time it's harder to manage the cost and it gets more expensive. But you know, generally for patent applications, there's the upfront cost in filing, and then there's a cost in prosecution. Those two can be broken out. Prosecution can be a little bit harder to judge, but if the scope of the invention is pretty well understood up front, that can be much easier to budget for. I guess that's kind of the important things. I think we're running out of time. Are we over time now?
We're over time, but finish your thought
Okay.
and then we can wrap up.
Yeah, I mean, and then you know that's the domestic. There's related applications. Will there be other applications that are going to be filed, and those can be incremental sometimes. And then there's the foreign, which can be significantly more expensive, and so well worth thinking through why you need it and where you should file, and how to limit that to control your costs.
Yeah, those are really great thoughts. And with that, we are at the end of our presentation. And thank you to the panelists here for their thoughts. And we hope that all the viewers found this webinar informative. Again, this is the first episode of a 3-part series. So we look forward to seeing you all again next month on June 26th for the patent prosecution episode. So thank you and goodbye.